Welcome to Frank Bruno Law. Failing to coordinate your beneficiary designations with your will or living trust. Failing to coordinate, let me think about that. Failing to coordinate your beneficiary designations with your will or trust. Okay, what does that mean? Well, there are accounts that have beneficiary designations. So, certain types of financial instruments, like a stock brokerage account, can have a beneficiary designation. Payable on death, transfer on death, joint holder. Now, what some people will do is they will have the beneficiary designation not line up with what they want. So I'll give you an example. Will may say, I'd like to leave to my children A, B, and C equally. And then on their bank account or their stock brokerage account, they have it joint with only child A. B and C will be left out, right? So that's a problem. Unless you really did only want A. It's good to call children by A, B, and C, right? We get to, I think it makes sense for the story. So did you want A to get all of the money in that account? Maybe. How about a life insurance policy? Do you want it to be 1/3 A, B, and C? Or do you want it to be, well, what some people do is they only have one child. So now they'll have child B. I mean, it may work out. You have A on the stock brokerage account and you have B on the life insurance policy. What happened to C? Poor little C cry all the way to the bank. Wee. So, final points about this topic, this area. Your will not trump. I don't mean in that person Trump's word. The will not trump the beneficiary designation. The beneficiary designation takes precedence. Okay. Now, a will can only govern and distribute assets that become part of the probate estate. And a trust can only disperse assets that were funded into the trust. This is a topic that we'll revisit. It's a hard, I don't know if it's that hard to grasp. I got it. And that's all you need, right? You need me to understand. Can a beneficiary contest a will? Why, yes, they can. In order to contest a will, you need standing. That means the ability to bring a challenge, an objection, a will contest. So generally there's 3 categories of people. A beneficiary of the will in question, a beneficiary of a prior will, beneficiary of a subsequent will, or heirs. So a beneficiary is a person named in the will. That could be a friend or another relative, or just someone that's named in your will. That's a beneficiary. As opposed to an heir, H-E-I-R, an heir is someone that would inherit if there was no will. So that would be a spouse or a child, depending on who your heir is at the time, who's alive at the time, right? So if a person that's married passes away, the living spouse is an heir. Or if they have children, the children are an heir. If a person is single with no children, their heir would be siblings, or really actually would be the parent first, if the parent was alive. So there are different categories, but a beneficiary can in fact contest a will. And it's not just based on the fact that they think that they should get a bigger portion, right? There's an actual reason. I'll get to that in another video. I took a question yesterday. A person asked me how to compel an inventory. So we were discussing what had happened, and the topic for today is, what do you do if an executor doesn't give you the information that you think is necessary or that you want to have, and you're a beneficiary of the estate? So the language the potential client asked was about an inventory. And I think what that person really needed was a different request, right? Probably a petition to compel an accounting. I think that's what was necessary, and that was where I steered the conversation. Now, what had happened is that it's been some period of time. The executor has not provided this beneficiary. This is a person that's named in the will and supposed to get 20% of the estate. And the executor hasn't taken the steps necessary to really complete the probate. And more than that the probate wasn't completed is that the beneficiary is not aware of how much money is in the estate, right? So 20% of some unknown amount could be zero, could be a couple of $100,000. So since this beneficiary has standing, right? So a fiduciary has to really be true to the estate, take in money, expend money, properly invest or divest from certain equities if there's a risk in keeping them, right? So if you have money in the stock market, maybe there's highs and lows, you might want to put that into a stable vehicle if the estate will be in existence for a little bit of time, right? The fiduciary has a responsibility to safeguard the money. So if you believe that if you're an interested party, a distributee, if there's no will, or a beneficiary, you can ask by way of, first, a regular request. Hey, can you give me this information? It can be done by letter or through an attorney, or just a simple request. If you get the information and you're satisfied, that's great. If you don't get the information, then you would have to do a petition to compel an accounting, and there'd be a citation. You have to serve it. It's an actual court proceeding in the surrogate's court. If you have any issues like this, please give me a call. We'll work through them. We file paperwork if necessary. We serve documentation if necessary. We will go to court and preserve your rights and fight for you. But we try and resolve things by a phone call or a letter first. What happens when a beneficiary in a will passes away and they have a spouse and children? What happens? Well, we have to look at the original document. Does the will say, I am leaving to, I'm going to make up a fancy name, Jane Doe. I am leaving the sum $10,000 Doe. Now, does that specific request then say, in the event that Jane Doe predeceases me, this request will lapse? That means Jane, it's kind of survival of the fittest. Jane does not outlive the original will maker, testator, person that's giving Jane $10,000. Jane doesn't outlast, then she doesn't get it. By virtue of that, her spouse doesn't get it. Her children do not receive the text. That specific paragraph can be written in such a way that go to the heirs of Jane. So it could be heirs of Jane, estate Jane. They might be different. Jane may have a spouse, children, and may not want to give money to them, or she might trust. She may give everything to Good Samaritan Hospital, Jude's Children's Home, or somewhere else. I don't even want to get into this spouse video for another. Does it go to Jane's estate, or does it go to the heirs of? Wouldn't include her spouse. What to do? Well, it starts with reading the document. We look at the will. Can we tell from a plain read? And if we can, then that answers the question posed. If we can't understand what the will says, because it's silent on it, we then refer to a big rule book or the law, and that would be the EPTL, the Estate Trusts and probate law. And I make the determination, the language of that paragraph matches up with the language in the law, and that'll help us determine where. If you need to speak with me, reach out to me, frankbrunolaw.com. Thank you.